Good morning, everyone. This is David Quam with Dentons in Washington, D.C. You are joining our weekly webinar series on covering all issues related to COVID-19. This is our 13th webinar during the pandemic and our stay-at-home orders. We are happy to be here with you on this Friday morning. Today, covering a very timely topic: return to work strategies. We are finding that we are in the midst of a real transition from response, which was the sort of initial everybody hold hands, go home, and make everything safe, to how are we going to emerge, get the economy restarted, and that includes topics of returning to work. We have a very distinguished panel, which I'll introduce here in just a moment. But for now, we're going to cover a few policy issues at the top of the hour, and then go to our panel to discuss some of the legal issues related to returning to work. Here at Dentons, we are the world's largest law firm. We have over 180 offices in more than 73 countries around the world. That means we have partners in all of the hotspots that have been dealing with the coronavirus worldwide. That range of expertise has really allowed us to try to serve our clients and our communities in the best way we can from both a legal standpoint and just being leaders within the community. We're happy to work very hard to protect not only our people, the interest of our clients, but try to help and provide free information to as many people as possible on how to deal with this unprecedented pandemic that has really swept the world. I really encourage you, if you have not, go to our website and our COVID-19 hub. There you can find information from all around the world. We have different trackers, both internationally and by legal issue. We also have a state tracker, which follows several state issues. Let's advance two slides, please. This is a chart I believe everybody knows well, the scope of the coronavirus disease across the United States. It is affecting, of course, every single jurisdiction. There is no jurisdiction that's untouched. There is no state that has not had to declare a state of emergency. But at this point in time, what governors are really working to do is discuss how do they reopen the economy. Anybody who's been following the news just today has seen that there's actually been a jump in employment, over 2.5 million jobs. So while we're still at over 13% unemployment for the United States, a very high number historically, the fact that states have started to reopen their economies, people have gone back to work, and that may be a trend that we continue to see during the summer. That being said, at the state level, how and when to reopen and how to respond if there's another spike in infections is something that all governors and health offices are dealing with. I know that governors are meeting on a weekly basis, talking with both the administration and each other on how to deal with these issues. And while there is a large move to both reopen economies and stage that as we move forward, and I think that trend will continue, there is concern coming out of both Memorial Day weekend and this past week with regard to gatherings across the United States that there may be a resurgence of COVID-19 in several states. Health officials are going to be very closely watching that to determine what the next steps are. All of this, of course, is relevant if you own a business and how you will operate moving forward. Again, I recommend that you go to our COVID-19 hub and our 50-state tracker to look at what is the latest from your state, both from the governor's office, the health office, schools. We also track your largest urban areas and your largest counties. Combining all of those together gives you a complete picture of what the response is within your state and the regulations that may be affecting your business or your clients. Hopefully that's information that's helpful to you. We update it every week, and we have teams tracking all 50 states. A couple of issues that are left on the table and will be coming up in the following weeks. One is, what will the federal government do next? It looks like from a timing standpoint that Congress, specifically the Senate, will take up a phase 4 bill at the end of June. This is something that we thought they might take up earlier in June or maybe act on mid-June for a July 4 delivery. Looks like that will be delayed, and that debate will go into the month of July. That bill is going to include a lot more money, especially for states and localities who, because of the shutdown, are really suffering budget holes of an unprecedented magnitude. Governors themselves have asked for more than $500 billion to help fill state budget holes. California alone, if you really wanted a strong example, went from a $6 billion projected surplus in January to a $56 billion hole just 90 days later. The reason that's important is states have to balance their budgets. So if you have a hole of that magnitude, you either have to raise revenues or cut expenses to fill that hole. Both of those can make a recession worse within the state. The relief, the state and local relief that's likely to come in phase 4, therefore, is one of the preeminent issues that will be on the table. A second one is the liability issue. And this is going to be key for several companies and employers, let alone institutions like those in higher ed. Liability relief should someone get sick, and making sure that the employer or the institution is protected from lawsuits as long as they are following some set of best practices moving forward. It is likely that there will be something at the federal level that provides some liability relief. There are also several states across the country starting to offer liability relief to their citizens. One of the first to pass such a law was Utah. It's being followed by several states who are under consideration right now as legislatures are in and trying to deal with their state budgets. One last federal issue. Just last night, the Senate has reformed the very popular PPP program as the Payroll Protection Program. It looks like anybody who's taken a loan under that program will now have more time to both use those funds, more flexibility with regard to loan forgiveness down the road, and more flexibility with regard to the ratio of the use of those funds for payroll versus other expenses, and still qualifying for loan forgiveness. Look for the president to sign that bill either today or over the weekend moving ahead. But that is a big change for a very popular program that's been used by many small businesses across the region. In the coming weeks, I'm expecting a lot of activity both out of the federal government and states as well as we move forward. Look for us next week to do a full webinar just on some of the policy implications and what's happening at both the federal and state level here on this webinar. Now, before I move forward and introduce our panel, one last issue I wanted to raise. Here at Denton's, we've been watching very closely all the gatherings around the United States and the protests. This is a very important issue for states, for our firm and our communities. Our well wishes are with everybody, that everybody is both safe and feels like they're able to express both their First Amendment rights, do it safely, and that both our cities and towns and communities find themselves in a discussion moving forward that can start to bring some resolution. That issue is also a health issue, as I mentioned before, concern for people gathering either with or without face masks, and hoping that everybody is both safe and uses the health resources available to them in the states to be healthy moving forward. It's an activity that we will continue to track. We know that both governors and the federal government are very concerned with making sure that peaceful protests remain peaceful and that everybody remains safe. Here at Denton's, our thoughts and prayers are with everybody. Let's move ahead one slide. If we can advance one slide, please. I now want to introduce our panel. First will be Louise Ng, who's a partner in our Honolulu office. She does employment and labor, she's in our employment and labor practice group and practices in areas of employment law and dispute resolution, as well as all types of business litigation. She's going to be joined by Kimberly O'Donnell from our Lexington, Kentucky office, who's also a partner in our labor and employment group, where she advises employers regarding employment issues and also defends them in employment litigation. Julie Vandeman is a shareholder in our Pittsburgh office of Dentons, Cohen, and Grigsby, and she counsels and represents clients in workplace health and safety matters and in environmental litigation and regulatory compliance matters. And then finally, Peter Stockberger is a partner in the firm's San Diego office and a member of the firm's labor and employment group. He focuses on all matters of employment law, data privacy, and cybersecurity. So a very distinguished panel to talk about the issues today. With that, Peter, I'm going to turn it over to you to handle the rest of the presentation.
Great, thanks so much, David, and good morning, everyone. Thank you for joining us for what we hope will be a useful and informative session on return to work strategies and legal issues that your organization should be thinking through as you plan to return to work. I think as David highlighted in the opening, we are obviously operating in very uncertain times, and so it's really more important than ever that organizations understand their risk profile, understand their compliance obligations with all of these new return to work and reopening phases, and map that out as they move forward into the new normal. And so before we begin our discussion, I just wanted to plug Denton's new Return to Work Toolkit that we published on Wednesday. And this Return to Work Toolkit is really a guide for organizations to use to understand what their obligations may be moving forward and things to think about. And so the toolkit has inside of it a useful checklist. It also has a robust Q&A session on some of the top issues facing employers as they start to return to work. So we hope you check it out, and it's useful. It's available on our website, and it's free to the public. The panel discussion today is really kind of a microcosm of that toolkit. We're going to be focusing in on 3 of the hottest areas we think on return to work issues. And that is, 1, what are the unique plans and documentation businesses need to reopen, both from the federal, state, and local level? 2, what are the laws and issues relating to masks? Who has to wear them? Can they refuse? What are your options? And then 3rd, temperature screening. Again, who needs to do it? What are the restrictions? What are the risks? And what are some best practices? So with that, I'd like to dive into the first topic, plans and documentation. And Julie, I'd like to kick it off to you first to highlight maybe some of the top issues from a workplace safety perspective, from an OSHA perspective, which really is top of mind for most organizations. What should we be thinking about from a documentation and plan standpoint in workplace safety?
Sure, thanks, Peter. So I'll start with OSHA, but I do want to say there are a number of states that have OSHA approved state plans, and they may have additional obligations on top of what OSHA is recommending. In March, OSHA published a guidance document encouraging employers to develop an infectious preparedness and response plan. So you've been told that you should have one of these plans. And part of what I want to talk about is why. Under the OSHA Act, each employer has a duty, generally, to have a safe workplace. And to do that, you have to be responsible for reasonably foreseeable hazards. I think we can all recognize at this point that there's a possible risk of transmission in a lot of workplaces because of the virus that causes COVID-19. So you need a plan to address those hazards, and it's important to document that plan. That will help you if OSHA ever investigates to help show that you were serious about your commitment to the health and safety of workers. So elements of a plan include a risk assessment. You need to identify the hazards that you see in the workplace and develop a plan to address them. Implementing workplace controls can vary depending upon the workplace. OSHA has what they call a hierarchy of controls, from most effective down to less effective. So I can't go through all of them, but just a few. If you look at engineering controls, these are things that don't rely on worker behavior. They're just there. So partitions or improving ventilation in office buildings. A little further down the hierarchy, you have administrative controls. these do require some type of action. So, for example, policies and procedures that tell sick workers to stay home when they're sick. And then further down that hierarchy, you have PPE, things such as gloves or face masks that prevent some type of transmission. So you have a plan, now you need to communicate it and train, because it doesn't do any good if it's just on paper. And then evaluate, are the plans working or is it not going as you thought it should? And finally, it's really important to stay up to date because there have been so many guidance documents issued, just literally hundreds from the CDC on different types of workplaces, from different jurisdictions, so make sure you stay up to date.
Great, thanks, Julie. And I forgot to mention at the beginning, if you have any questions on any of these topics, feel free to use the Zoom chat function. I'll try to weave in those questions as we go along. Julie, your comments really kind of highlighted, for me at least, where you mentioned policies and procedures and communication, this need to have sort of a robust employment policy program as you return to work. And I really think workplace safety is just one component. And so, Luis, I wanted to turn to you. And what are aside from workplace safety, what are some of the other employment documents, plans, policies that employers should be thinking about in this return to work phase?
Thank you, Peter. Well, businesses and employers in general need to be rethinking their employment policies. And here are just a few topics of areas in which they should be rethinking. Access to the workplace, timekeeping, compensation, leave, operational issues, business travel, work from home. What I mean by that is that with respect to accessing the workplace, are there going to be criteria for entering the workplace, such as the temperature checks that Julie mentioned, cloth coverings to the face and the like. With respect to timekeeping, for employees that do need to keep time, there will be all types of new time to track, such as if there's going to be a temperature checking and the like, there'll be waiting time, time to self-check if there are going to be questionnaires, time to do all the new operational or things that need to be done in terms of cleaning one's workspace and keeping a good hygiene. With respect to bonus and compensation, for instance, this is going to be a very different year than what was planned in terms of bonus and compensation criteria. That needs to be rethought. With respect to leave, our federal laws under the FFCRA have imposed expanded sick leave and family leave that needs to be considered. Operational issues include such things as how is one going to conduct a meeting? Are there going to be meetings at the workplace? Will there be other modes? Rules on spacing, office etiquette in terms of safety and hygiene, what to do if one is sick, which is still the basic. If you're sick, report your symptoms, don't come to work, don't infect others. Business travel, it's not going to be taken for granted anymore. There are going to be limits that need to be considered in light of CDC guidance. And then with respect to working from home, will there be a continued work from home policy? And if so, what kind of monitoring and checking in will there be, clocking in, clocking out, and the like? So those are just a few, Peter.
Yeah, I think what you talked about, Luis, raises an interesting conundrum for organizations as they're planning right now is, do you just update all of your existing handbook policies and reissue them on a piecemeal basis and get acknowledgement, or do you put together this sort of return to work playbook or handbook that you're handing out? And that's a core thing that organizations should be thinking about right now. Kim, I wanted to toss it over to you. We've been talking about the federal issues, OSHA, some of the larger employment issues. What's going on at the state and local level? Because I know each one of these jurisdictions have unique plan and documentation requirements for reopening.
That's a great question, Peter. So as mentioned, each state has different requirements for employees returning to work and different standards for businesses to meet. So each employer needs to look at each state in which it operates and then determine what the requirements are for those states in which they operate or which they have offices. This has been a large undertaking for many businesses that operate in numerous states. And of course, we don't have time here to highlight all the requirements in the different states, but I thought that I might highlight 3 different states for this section of the presentation, California, Pennsylvania, and Kentucky, just so you can see how different states are addressing these questions. California has required all businesses that are reopening to perform, first of all, a detailed risk assessment and implement a site-specific protection plan for their companies when they're returning to work. And those sample plans are available for employers online. You might look at your specific county, or it's also available on the California state government's website. Second, the state is requiring that employers train employees on how to limit the spread of COVID-19, including how to screen themselves for symptoms and stay home if they have them. We'd recommend that any California employer document the fact that they have provided the training required under this section of the governor's order, and specifically state how they have trained employees to screen themselves for symptoms, but definitely document which employees have attended those trainings. Third, they require that you implement individual control measures and screenings, also implement disinfecting protocols, and finally implement physical distancing guidelines. So there are 5 requirements for business reopenings in California. Pennsylvania has also taken a little bit different stance and is requiring that businesses that reopen and are were permitted to operate during the closures display a notice titled COVID-19 Safety Procedures for Businesses at each working location, building, or work site. And in addition, Pennsylvania is requiring that each business must provide for each work location, not just for the employer, but for each work location, the identity of a pandemic safety officer to respond to employee and subcontractor questions regarding any reopening requirements. Similarly, Kentucky has put forth a 14-point list of things that it wants each employer to do when it's reopening, including continuing telework where possible, allowing phased return to work. I know many businesses here in Kentucky right now are operating at 25% employee capacity, and they're moving up to maybe 50% in July, and doing that phased return to work. Obviously enforcing social distancing, which we've heard a lot about, limiting face-to-face interaction, no more employee meetings in a conference room or things like that. They're encouraging Zoom meetings and things of that nature so that employees can keep their distance even if they're back in the workplace. Masks and other necessary PPE, which we'll talk about in just a minute, hand sanitizer and proper sanitation. Kentucky's requiring that each employer conduct daily temperature and health checks, which we'll also talk about in a minute. And then create a testing plan, and also, like Pennsylvania, designate a healthy at work officer. So those are just some of the requirements here in Kentucky, but you can see each state is addressing return to work policies in a different fashion, and it's important that employers stay up to speed as to what the requirements are in the states in which they operate.
Yeah, I think what you're highlighting, Kim, goes back to what I mentioned at the beginning, which is before you can even start to go down the reopening path and build out those policies, you have to map out each of your jurisdictions, even down to the local county level and the city level, because they can vary widely, especially in California. I want to shift gears now to the second topic, which is masks, which we've all sort of touched on in the policy and documentation. But who needs to wear them? Where do they have to wear them? Do I have to wear it in my office? You know, all these questions that are going to come up. And so, Julie, I wanted to toss it back to you in this Brady Bunch square image here. I'm going to throw it to the left. What does OSHA say about masks?
So I'll start just by saying that the term mask is problematic because it's too broad. Different rules apply to different workers in different kinds of settings. And so employers need to know what they're recommending or requiring and why. So starting with face masks that are PPE, these are surgical masks that are fairly loose fitting. They provide some protection to the wearer. And then there's the N95 respirators that are tight fitting and that do reduce exposure. It's beyond the scope of this presentation to talk about specific standards for PPE. Cloth face coverings prevent the person from spreading respiratory droplets, especially to somebody within 6 feet. They're not necessarily protecting the wearer. So the CDC issued guidance fairly recently about manufacturing settings, and in that guidance, they specifically said cloth face coverings are not PPE. They are not appropriate substitutes for PPE, such as respirators or medical face masks in workplaces where those are required. So I just wanted to note that distinction between cloth face coverings and actual PPE subject to OSHA standards. Keep in mind, though, that under the general duty clause, you're supposed to identify reasonably foreseeable hazards. So if you know that you're in an area where it's possible workers are transmitting the virus, and you know that face coverings are a feasible means of reducing transmission, and yet you're not requiring them in settings where they could help, then you could be more at risk at the conclusion that you're not protecting your employees from reasonably foreseeable hazards.
And so, Kim, building on that, it seems that where OSHA has the general guidance, that the requirement to wear masks or the very specific restrictions on who can wear them and what types might come at the state and local level.
That's absolutely right, Peter. Each state is treating this differently. And once again, I just pulled some states to highlight here. Obviously, we don't have time to go through all 50. But some states, for instance, Maryland and Indiana, are requiring masks or cloth face coverings for employees of certain sectors, like Julie mentioned. So in Maryland, all retail establishments are required to have staff wear face coverings while working in areas open to the public and in areas in which interactions with other staff members are likely to occur. So for instance, if those retail establishments have private offices, for some folks, they don't have to wear the mask while they're in their private office, but if they're interacting with staff or the public, then they do have to wear them. Maryland's also requiring that employees of personal care services wear face coverings. So places like nail salons or hair salons or those sorts of things that are public facing, Maryland's requiring that employees of those facilities wear masks. Similarly, Indiana is requiring face coverings for restaurant employees and for personal care services employees. Neither of the guidelines in Maryland nor Indiana mention manufacturing workers or folks that are just working in typical office buildings and things like that. On the other hand, you've got states like Massachusetts, which is requiring that all residents over the age of 2 years old must wear face coverings while in public settings. And this includes any employees in any essential business that is currently open or while on public transportation. So Massachusetts' requirement is far broader than Indiana and Maryland. And like I said, requires that any employee in any essential business be wearing a face mask while they're at work.
Oh, sorry, go ahead.
Go ahead, Peter. No, go ahead.
I was going to say, a question just came in as you were bringing that up, and the question is, are employers required to provide face masks as equipment to employees? And you know, from my view in California, which is always different from everybody else in the country, is you've got to reimburse business expenses on that level if it is a tool for employment.
I think that's right, and it may vary by state. Most of the states that I'm seeing, including Kentucky, here where I am, the state is requiring that employers allow employees to bring their own masks or provide those face coverings. I don't know of any state that's requiring necessarily, like Julie made the distinction between N95 respirators and cloth face coverings. I'm not aware of any state that's requiring employers to provide 95 respirators or surgical masks simply because of the low supply and the fact that we want to save those for the healthcare providers. But there are states that are requiring employers to provide the cloth face coverings for employees. And I was just going to say really quickly, also there are the state requirements, like you mentioned, Peter, local requirements. So certain cities are requiring things above and beyond what the state may be requiring. For instance, New York City has different requirements than the state. So you might look at your local government requirements as well.
And it seems also that requiring folks to wear masks or providing masks and having policies, it's going to trigger also accommodation issues. And so, Luis, maybe you could touch on some of the higher ADA accommodation questions that come up when we're talking about masks in the workplace.
Sure, Peter. Yes, employers need to think about the fact that before they mandate the use of face coverings, that they should plan a response if employees do refuse to wear those face coverings, which can often be not the most comfortable things. And that includes needing to know when there is an obligation to engage in a reasonable accommodation process, and what kind of enforcement mechanisms employers are going to use. Whether you're going to consistently enforce it, make it a rule or a recommendation, and whether there should be progressive discipline, even termination if employees insist on breaking rules in the workplace. But before they even get to that, employers need to be sensitive to situations that may require reasonable accommodation, particularly if an employee has a health condition that makes it risky for them, for instance, like a respiratory condition. And so they need to be sensitive to employees raising those issues and then engage in a case-by-case interactive accommodation process, which may include, isolating an employee so they can have their own workspace where they can work without that need, or reducing their need to be out in public spaces of the office where a cloth covering may be needed. So employers need to be aware not only of the federal disability laws, but also their own state and local laws and regulations in order to implement an effective policy about wearing cloth coverings. Something to keep in mind too, just a practice tip from retail from a webinar I had listened to, is that one way to build acceptance is to turn the wearing of those items into a positive branding opportunity, for instance, for a company, or to make it part of the company ethos or PR. Wearing is caring. You're taking care of not only yourself, but your coworkers and customers by wearing this at work. So those are just some thoughts, Peter.
Great, and I know we're up on the time clock here, but I want to do a quick lightning round, wrap this up on a topic that obviously can be addressed easily in a lightning round: temperature taking. So Julie, I want to kick it off with you from an OSHA perspective. What do the listeners need to know about temperature taking?
So temperature taking can be one component of an overall strategy because you've already written a plan, like I talked about earlier. But I would emphasize that you should not overemphasize the importance of temperature screening, because we all know from news reports that there's a lot of asymptomatic transmission. So by screening, you're not going to catch people who might have it and aren't showing symptoms yet. That said, it is one way to eliminate the possibility of people in the workplace with COVID-19. OSHA does not have any guidance saying everybody has to do it at all times, and neither does the CDC, but there are warnings. So for example, if you're conducting temperature screening, be really careful about the person conducting the screening, because they may need specific PPE or strategies in place to protect them. Screening is required in certain circumstances, and you need to know what those are. For example, the CDC has guidance about critical infrastructure workers who have been exposed, but have had an exposure, who have been exposed but are asymptomatic and are continuing to work. There are also jurisdictions that require screening in certain circumstances, and those vary by state and they vary by timing, and they be based on whether somebody's been exposed at work.
Jim, over to you. What do we need to know for temperature screening at the state and local level?
Similarly to the other sections that I've presented, you need to be aware of what the states are doing in which you operate. So some states have not addressed the issue of temperature screening at all, whereas some states like Ohio have issued guidance strongly recommending that each employee have their temperature taken every day, but it's not a requirement. Here in Kentucky, it's required that all employees have their temperatures taken either by their employer every day or that they certify a self-test every day. And then some states have taken the measure of going and treating certain industries different than others, like for the face coverings that we just talked about. For instance, Delaware requires that certain high-risk businesses, such as hospitals and childcare facilities, implement screening questionnaires and even go as far as temperature checks every day. So there it's industry specific. So once again, I would encourage employers to talk to their attorneys about requirements in the states in which they operate, and also see if there are any specific requirements based on localities and local governments.
Luis, to wrap up our lightning round, what do we need to know about temperature taking in the ADA? What has the EEOC said in this state?
Well, employers are well advised to go to the EEOC's website and read about what the guidance is about temperature checks, because generally they should be aware that under the disabilities laws, temperature screenings and checks are not allowed. However, when we have a specific situation that poses a direct threat to the workplace, as we have with a pandemic situation, in that situation, EEOC has said that temperature checks and screenings can be considered lawful, but they do need to be tailored to the particular situation and need. And also confidentiality and privacy needs to be kept in mind. So if temperature checks are done, certain screenings are done, employers are keeping records, they need to be very careful about keeping those records confidential.
And I think before we wrap up, I would be remiss as a data privacy lawyer if I didn't put in a plug there for, if you are collecting that temperature as a confidential medical record, you've got to be thinking about your data privacy and your cybersecurity requirements. For example, if you are a covered business under the California Consumer Privacy Act, a new law that took effect in California on January 1 and applies to companies wherever they exist in the world, if they're doing business in California and meet certain thresholds, you will have to be providing express, conspicuous, and clear notice to job applicants, employees, customers, and contractors about the categories of information you're collecting and how you're going to use them. And the definition of personal information under that law includes thermal information and information relating to a medical condition, which would include temperatures, which would include symptoms. So you've got to map out those obligations, get those notices in place, update your privacy policy. And if you are going to store that data, which we don't necessarily think is a great idea, but if you need to, for whatever reason, ensure that it has appropriate controls and security around that data. So with that, those are some of the high-level issues we wanted to identify from the toolkit. We hope you look at the toolkit, and of course, feel free to reach out if you have any questions. And thanks for participating. David, back to you.
Well, thank you so much. It was a fantastic panel, very timely for, I'm sure, everyone on this call and for everyone really across the country. I did see one other question that popped up on the chat. Can you address employer liability? Will the federal government provide relief for employers? That issue will be front and center in the U.S. Senate when they take up a Phase 4 bill at the end of this month. The Leader McConnell has said liability relief is a key for him with regard to that bill moving forward. The other half of that is help for state and local government. You've also got Lamar Alexander, one of the leaders in the Senate, and certainly with regard to education, saying that he wants relief and liability relief for institutions of higher education to make sure some of our universities can open up this fall. So it is an issue I expect to be front and center in that debate. I do believe it will be addressed to some degree at the federal level. I also know that several state chambers of commerce are taking this up at the state level right now, with some states already having passed some liability shields. Many more are likely to follow. We'll probably do a separate webinar just on that issue in the coming weeks as both the states and the federal government take it up. So thank you for that question. For everyone who's joined us today, thank you for being part of this webinar. Again, we do this every single Friday. This is our 13th. All of them are available on our website. A recording of this presentation will also be available to you later today. If you have any questions, we are here to help and would welcome any questions to any member of the panel, to myself, or to anybody else at Denton's. We are here to serve, help our communities, help our clients, and help you as we all get through this. We are all better together. Be safe, be healthy, and have an excellent weekend. Thank you, everybody.